Hello, my name is Rachel Buss, and I'm the Managing Attorney at Law Offices of Brelje and Associates. Today I want to talk to you about a policy memo that will be taking effect on September 11th. This is USCIS Policy Memo number 602-0163. You can find this policy memo online at www.uscis.gov. What this policy memo does is it will, beginning on September 11th, take away the discretion that officers have to issue a request for evidence or a notice of intent to deny in cases in which initial required evidence is not included with the application, or in which there is no legal basis for the application or the petition. The examples that USCIS gave in putting out this policy memo are, for instance, in the case of a waiver application in which somebody has to demonstrate that they have a qualifying relative and the application filed does not include any evidence that they have that qualifying relative. So in other words, there's no legal basis for the waiver that they have filed. So in that case, they would simply deny the application without issuing a notice of intent to deny or a request for evidence. The other example that USCIS gave is in the case of a relative petition in which somebody is requesting to adjust status, so in other words, seeking their green card, and the application did not include an affidavit of support. That's required initial evidence in that case type, and so the officer could deny the application without issuing a request for evidence or a notice of intent to deny. The purpose of this new policy is to deter people from filing applications or petitions as placeholders while they seek other benefits. So, in other words, although this does cause concern because it gives officers a broad new basis to deny petitions, it does not mean that when we file a petition and there's a substantive question as to eligibility, that the officer would deny that type of petition. So, in other words, in an H-1B petition where somebody is filing a petition claiming that the occupation is a specialty occupation and it's not clear to the adjudicator that the job does meet the qualifications for a specialty occupation, the officer will still issue an RFE, or should still issue an RFE in those types of cases. On the other hand, if we file an H-1B petition that doesn't have an LCA, a labor condition application, included, in that instance, the officer may and most likely will deny the H-1B petition because that's a piece of initial required evidence. I want to assure our clients that we will continue filing petitions that are complete, that are accurate, and to the same high standards that we always have. We don't anticipate that petitions are going to be denied under this new guidance. We will continue to carefully use our internal processes to check petitions to make sure that they are complete before filed. And we want to assure you that that has always been our policy and it will be our policy going forward. If you have any questions, please feel free to visit our website at www.brelgelaw.com. Email us. My email address is rbus@brelgelaw.com. And we look forward to continuing to provide the high quality service that our clients expect and deserve. Thank you.